Okay, well, live on YouTube, trying to connect Instagram. Okay, I think there's some issue connecting Instagram. Okay, I think we're unable to connect Instagram, so maybe we'll stream on YouTube for now, and we apologize for any inconvenience caused. So we can start the
Yeah, yeah,
session if
sure.
you're good to
Go
go,
ahead.
sir. Okay. Good evening to everyone who's tuned in. Today we'll be discussing upon the theme of beyond citizen oversight, problems with this trade-off between transparency and privacy. Allow me to introduce you to our speaker for the evening. Uh, Dr. P. Arun is a research fellow at the Lakshmi Mittal and Family South Asia Institute, Harvard University. He holds a Ph.D. in political science from the University of Delhi. A very, very warm welcome to you, sir.
Thank you. Thank you, Tia, for inviting me.
Yeah. So, with reference to your article for EPW, which discusses upon this theme in detail, how does the amendment to Section 8, Part 1J of the Right to Information Act affect transparency and access to information, especially public interest? Do you think that the blanket exemption incorporated under Section 44, Clause 3 of the Digital Data Protection Act is justified in its claims of safeguarding individual privacy?
Yeah. So before going into this amendment, let me just briefly talk about this RTI Act as how it originated.
Sure.
The Right to Information Act or the RTI Act emerged from the grassroots campaign, which later on evolved into a vibrant people-led political movement claiming the right to
Yeah.
information, and it emerged from the voices of people and strong mobilization at grassroots level. uh, RTA Act stands as a symbol of people movement and thus makes it the citizens being authors of their own right. If you look, the Indian
Yeah.
courts had recognized this even prior to the passage, but uh, as a statute, the RTI Act gives this right to access information. Uh, it formalizes. So instead of approaching the court, now we are directly approaching the government, where the government is supposed to place a public information officer and appellate authorities who from whom the
Yeah.
citizen will seek information in a time bound manner, as the RTI request needs to be replied within 30 days. So in 2005, the government
Right.
passed the RTI Act, which empowered citizens with this right to access information and hold the government accountable in a democracy. Under this, citizens seek
Right.
answers to fight corruption, injustice, and challenge the arbitrary power. So, 2 decades back, RTI Act was introduced to fulfill the state's positive obligation to realize the constitutional right, and is therefore what Gautam Bhatia called the constitutional statute. However, if you look,
Right.
the right to information is not absolute right, as many other right. It's not an absolute right. Therefore, the act prohibits access to certain information, and this includes information
Yeah.
related to national security, or information held by the intelligence and security agencies, trade secrets, intellectual property, or information which threatens individual life and personal safety, or which impedes investigation or prosecution, third party information, and many more. So when we look into this section 8.1 of the RTI Act, there are like 10 exemption listed over there, from subclause A to subclause J,
Yes.
which includes the subclause. The last one is subclause J, which exempts access to personal information. Now, as 2 decades have
Right.
passed, and RTA Act is most relevant in today's time, uh, it's relevant because as a democracy requires informed citizenry and transparency of information, and they are vital for functioning of a democracy in order to contain corruption and hold the government accountable to the governed. Now, with this
Yeah.
amendment to the Section 81J of the RTI Act, introduced under Section 44(3) of the DPDP Act, it is Data Protection Law, it marks a significant departure from the one of the core objectives of the RTI law, which
Yeah.
is, I quote, it is necessary to harmonize the conflicting interest while preserving the paramountcy of the democratic ideal. Even the Supreme Court, in its landmark 2017 Putas Swami judgment, which
Yes.
recognized privacy as a fundamental right, had
Yeah.
cautioned that formulating a data protection regime is a complex exercise,
Yeah.
as it requires a careful balancing of privacy and other values.
Right.
In original RTI law, as it was in 2005, Section 81J denied access to personal information, but not absolutely. So it had a balancing mechanism under which personal information can be provided if it was relevant to public activity or public interest, or disclosure is justified
Right.
in the larger public interest, even if it causes invasion to the right to privacy. However, this
Right.
mechanism has been discarded. So this balancing mechanism has been discarded under this data protection law. The amendment
Yeah.
introduced a blanket exemption for personal information, regardless of whether it is relevant or to public interest or public activity. Now, what happens is this fundamentally alters the core purpose of the RTI Act, as the amendment disempowers the citizens to hold the state accountable. While the government claims, on the one hand, that RTI, this amendment safeguards individual privacy, but
Yeah.
when we look into the legal framework of the RTI and the judicial pronouncement, we get a different perspective. So the law clearly is framed as, initially, it had already had all the robust safeguards in place, balancing both the transparency and privacy. But this amendment is not enhancing privacy, rather it is discarding transparency in the name of privacy. Also, when we come into this
Absolutely.
judicial pronouncement, Supreme Court, in cases like Talapalam Cooperative Bank case and Subhash Chandra Agrawal case, it held that RTI law satisfies the constitutional test of legality, legitimate aim, proportionality, when there is a disclosure of personal information. So the law already prescribed that information officers are required to balance privacy concerns against public interest before disclosing personal information. Now, by removing this existing safeguard, the amendment shields the public officials and institutions from scrutiny. Even in cases where disclosure
Right.
is clearly in the public interest, such as corruption, misuse of public funds, human rights violation, these are not trivial matters. They are essential for democratic oversight. Now, RTI amendment is placing such information beyond public reach. So I would say that this blanket exemption is not justified. It undermines the constitutional right to
Right.
information. It weakens democratic accountability, and it prioritizes bureaucratic secrecy over public oversight. So what I believe is a robust data protection regime must protect privacy, but not at the cost of transparency.
Right. Thank you for laying out the context in such fine detail for us. Indeed, the impact of RTI has been massive in India, and therefore, any amendment to it should be tackled with the same degree of seriousness. Um, in your article, you also mentioned that this RTI amendment was not part of the initial three draft data protection bills, but was included unexpectedly in the final iteration. Why do you think that was the case? And what were some of the responses to the rushed passage of this amendment by our political dispensation, our civil society, and citizen groups?
Yes, so the RTI amendment was not part of the initial three draft data protection bills. So it was sudden inclusion in the final version, and it was quite unexpected. It was widely been
Yeah.
condemned by many civil society members and even former information commissioner and opposition leaders like Jairam Ramesh and many other leaders have warned the consequences of this amendment. So a former chief information
Yes.
commissioner. M. Sridhar Acharyu says RTA amendment transforms the RTA into a right to denial of information. So this sudden
Mm.
inclusion appears to be strategic as it bypasses the extensive deliberation and consultation which were going on and which happened in earlier draft. So it just bypasses all the consultation, and with sudden inclusion, no, there was they didn't accept as many deliberation which were given even at that time. Also, if you look
Yeah.
the DPDP bill, which was passed, it was so much rush, and there were very limited parliamentary debate, despite significant backlash outside Parliament, and even during the parliamentary debate, the questions were raised by the many opposition parliamentarians on this amendment. Now, though
Hmm.
DPDP bill got passed in the parliament and received presidential assent, it has not come into force at this stage. And the
Right.
government did not announce any date when the law will come into force. So this is a very
Right.
crucial juncture, and this time civil society groups, citizen coalitions, and opposition leaders are engaged in appealing the government to roll back this amendment. So even Jairam Ramesh have appealed. He said that the RTA amendment is going to destroy the RTI, and he urged the government to pause, review, and repeal this amendment. So even this a collective of 30 organizations have launched a signature petition demanding the rollback of this amendment.
Right. Uh, There have also been varied interpretations of the Putas Swami judgment, which you mentioned previously, that have come up in light of this debate. While our IT minister has claimed that this amendment resolves the contradictions between privacy and the right to information, some members, such as MP Jairam Ramesh, have outrightly dismissed the need for such amendments by observing that nowhere in the Puttaswamy judgment mentions that the RTI Act needs to be amended. What are your thoughts
So
on
the
the same?
government, particularly the IT minister, has urged that the amendment
Hmm.
aligns with the Supreme Court landmark 2017 Puttaswamy judgment, which recognized privacy as a fundamental
Yeah.
right. However, this interpretation is
Yeah.
contested as leader like Jairam, opposition leader like Jairam Ramesh and others pointed out that the Puttaswamy judgment never mandated amendment to the RTI. In fact, the judgment emphasized that there is a need to balance privacy with other values, not to protect privacy at the cost of other rights. Even Justice
Right.
Chandrachud, who authored majority opinion into Puttaswamy judgment, 2 years later, in 2019, Subhash Chandra Agrawal case, which dealt with the declaration of judges' assets, affirmed that the RTI satisfies the proportionality test. It ensures that privacy is not disproportionately harmed in the pursuit of transparency. So I believe the grounds to pass RTA amendment appears to misinterpret Puttaswamy judgment and using it as a pretext to curtail access to information rather than harmonizing the competing rights.
Sorry, I think I missed the last part of your
Yes. So
sentence.
yes, so I was saying the grounds of using RTI amendment is not justified. It's a pure misinterpretation of what the Putas Swami judgment said, and this amendment is using Putas Swami as a pretext to curtail access to information rather than harmonizing the competing rights, which is privacy and transparency.
Right. Uh, you also argue that the access to personal information becomes critical in certain cases. Can you illustrate the same with a few instances where you think that is the case?
Yeah. So access to personal information and RTI Act has been crucial in a democratic oversight, particularly in India, and it plays a very crucial role in exposing issues like corruption, ensuring accountability, and protecting human rights. Some illustrative examples would be like
Right.
uh, infrastructure failures. So citizens using RTI to identify contractors who were responsible for poorly constructed roads or bridges that collapsed. And RTI can also play
Yes.
in cases of mass violence and custodial deaths. RTI can be empowered, it needs to be empowered, and it can play, it has been instrumental in certain cases while accessing FIRs, investigation reports, or prosecution records in cases of communal violence or
Right.
police brutality. There are rejection, but it needs to be empowered, and RTI can play a very important role. And also when it comes to the human rights monitoring, so organizations like Human Rights Watch have filed RTIs to verify whether police followed legal procedures during arrest and detention. So in a democracy, information plays a very important role, and it reveals what the government do, how they do, and why they do. In numerous cases, the access to information is linked to some personal information. It's not just bare information we sometimes seek. The information is related to someone and some person or something like that. So its disclosure is important in larger public interest. Yeah, so it needs to be balanced, both transparency and privacy.
Right. And like you mentioned earlier, it's not merely a matter of privilege. It's not some trivial issue that we're taking up. These are very personal and very important and political matters that citizens do need
Yes.
access to information to. And I also quote from your article wherein you put up the point which says information does not exist in isolation. Rather, it is situated in a
Right.
political context.
Yeah. Yeah, so the information need to be seen how where it is actually placed and how it is being used in order to both deny access to such information in a particular political context. Yeah.
Yes, absolutely. You also argue, sorry, you in your study of the Central Information Commission's data, what does the data reveal about the implementation of the RTI
Yeah,
Act?
so I was accessing this data from Central Information Commission, and the annual reports reveal something very interesting. So the annual reports of last 10 years reveals that a very disturbing trend. The government has increasingly invoked
Yeah.
Section 81J compared to other exemption under Section 81A to I. So Section 81J
Right.
particularly deals with this access to personal information, and it has been used numerous times. So the statistics, what I have found is over the span of 10 years between 2014 to 15 and 2023 and 24, this ongoing, the previous one, Section 81J was invoked
Okay.
average around 15,000, over 15,000 times. And it was in the peak in 2016 and 17 with over 18,000 times. So the data shows that the public authorities heavily relied on the privacy exemption under Section 81J. Even before the RTI amendment
Hmm.
indicates systemic efforts to deny information. Now the RTI amendment formalizes the trend, removing the public interest override and further weakening the RTI framework. Yeah.
Right. So perhaps we ought to not only reflect on the contours of the law, but also on how that law is then implemented, interpreted, and used by
Right.
various authorities
Right.
in India. Um, Finally, in conclusion, what are some of the ways in which we can strengthen transparency and privacy within the framework of the RTI?
Yeah, so there are few things which can be done to uphold transparency and privacy. The first is to restore the original clause under Section 81J. The government must remove this
Yeah,
blanket exemption and keep the clause framed initially in RTI Act 2005, as it allowed disclosure of personal information, but when it justifies public interest and public activity, and there are officials, the government officials are there, they have to make judgment, even appellate authorities are there, even if they deny it, then they can challenge it in the court. So there was an entire process for in order to balance both privacy and transparency. Second important thing, information
right,
commission needs to be strengthened. The government must ensure timely appointments, clear the backlogs of pending cases, backlogs because it is the information is denied based on one of these exemptions, Section 81J. So this entire backlog on that, and for in order to clear, you need to have information commissioners over there. And the conflict
absolutely.
can be only resolved when this information commissioners and the appellate authorities are there, and even the courts are there to interpret this tussle. So these are the two major things we can do in order to strengthen the transparency and privacy.
Right. I think with that set of remarks, we can call it a wrap to this particular live conversation. Thank you to everyone who patiently tuned in, and we apologize for the technical errors we faced at the start, such as the nature of life. We'd also like to take out a moment to request you to support EPW and subscribe to us on our social media channels as well. For anyone who's interested in reading more about this topic, the article is available on our website. You can access it there. Thank you again, sir, for providing key inputs about this extremely nuanced debate over the recent amendment of the RTI Act. And we can only hope that the journey is um, takes us to a path wherein citizens can continue to access the information they need while balancing it with the right to privacy.
Thank you for inviting me. Yeah, thank you.
Thank you and
Yes,
have a
yes.
wonderful
Have
evening.
a wonderful